Great. Good afternoon. Thank you for joining us today. My name's Jeremy Glover. I'm a partner at Fenwick Elliott, and I'd like to welcome you to our second webinar in our series, which today we'll be looking at the impact of COVID-19 on both construction contracts and construction sites. Our speakers today will be Fenwick Elliott partners John Miller and David Bebb, who, amongst other things, have been assisting with the Construction Leadership Council in the drafting of the COVID-19 contractual best practice guidance. So without further ado, over to you, John.
Jeremy, thanks very much. What we're going to deal with today in this webinar basically is dealing with what's happening with existing contracts with COVID-19 and what people need to do to protect their position or what they should have already done. Also looking at the latest site operating procedure, SOP4, that was issued, I think, on Tuesday, to explain the way that affects building sites and what also needs to be done if you are or are not operating SOP version 4. My colleague David Bebb will be looking at new contracts, works going forward, what needs to be done if you're embarking on a new project. But to be fair, there are lessons to be learned in David's section, which applies to existing projects as well. I make no apologies for trying to avoid the law as far as possible. What we're trying to do is to explain what needs to be done, commercially speaking, on building contracts. However, being a lawyer, I cannot resist the urge to mention just an outline of the law in some shape or form. Essentially, what we're talking about with COVID-19 and construction contracts is force majeure. There's a lot of guidance written on this throughout the internet, which you can see. In very broad terms, most lawyers only look at this, certainly construction lawyers, at university. It's a new concept. But just some very, very basic points. First of all, force majeure only applies if you have a force majeure clause in the contract. If it's not there, it does not apply. It's not a point of general principle. And because of that, the words used in the contract to describe force majeure are vital. And to apply that to the sort of contracts that hopefully you'll be seeing day in, day out, on a JCT contract, the words force majeure are used, no more, no explanation. And there's even a case quite some time ago where the court held a term that said the usual force majeure position will apply was held to be invalid. It was too vague. I'm not saying that the force majeure clause in the JCT contract is invalid, but it's the wording used. And it's as simple as that, force majeure, and the JCT says nothing else. If you contrast that with, say, an NEC contract, it talks about a risk that had such a slight chance of occurring, you would not have expected an experienced contractor to have taken it into account. Foreseeability is a key point of NEC, but not necessarily JCT. And a clause that says whether you're hindered is treated differently as to a clause that says force majeure must render performance impossible. Now, just a little bit more on that. Please bear in mind that whatever protection your contract gives you, you have to invoke it. You have to give a notice. And without a notice, there is no protection whatsoever. And what we saw a few weeks ago when works were being suspended or halted so people could take account of what they were going to do next, how they were going to adapt their way of working, there were quite a few notices given then. Now people are returning to site, building sites are starting to take off. I should stress another notice needs to be given to take into account the delay on the progress of the works of the whole new working regime that we are now all subject to. Now, we have something like 50+ projects which have COVID issues. That's just from a straw poll amongst my colleagues. And as of a few days ago, not one extension of time had been granted, even when a notice had been given, obviously. So no one was granting extensions of time. We spoke to one of the senior partners of one of the leading consultants in the country who mentioned that their staff had some difficulties in the sense of no one wants to be the first person to grant an extension of time due to force majeure. What we're finding is that quite often the response you get is, thank you very much for your notice, but please explain what you're doing to mitigate delay. Please explain the best endeavors that you are using. And contracts like the JCT actually say you must use best endeavors to try to mitigate or reduce the delays. Unfortunately, legally, there is no definitive definition of what best endeavours are. There are some cases that say rather usefully, best endeavours are more than reasonable endeavours. One of the leading textbooks says that it would require you to spend some money, but possibly not a substantial amount. So there's no clear legal definition of what best endeavours mitigation is in a delayed COVID situation. My suggestion is that certainly off-site activities should continue. There's no reason why the design should not continue when the sites were shut down, and currently, provided they're keeping pace with progress on site. I'd certainly expect people to reprogram their works to take into account the new site operating procedures. And certainly replacing staff who do not come to site would be part of, I would suggest, best endeavours. Now, the key point of best endeavours is that you really do need to record what you're doing. If there is going to be an argument in 6 or whatever months' time, you need to show, yes, I did try to replace staff. Yes, I did do this. And it's simple. It's emails. It's notes. It's simple as that, explaining how you try to proceed best endeavours to mitigate and reduce the loss. Turning to what's actually happening on site at the moment, the CLC have issued these site operating procedures. They tend to be the go-to documents. They say that they reflect Public Health England's advice, and the latest version of SOP, as it's known, version 4, came out, I think, on Tuesday evening. It is supposed to reflect the government guidance that came out last week, which talks about building sites and other outdoor activities. And I don't want to get into a debate there about whether all construction operations are really outdoor, but there is a government document which explains what should happen on the building site, and SOP version 4 tries to give a bit more detail of it. Now, there are a long list of suggestions, but some key points. Okay? What the SOP does not say is that if you cannot keep 2 meters apart, you must stop work. It accepts that you have to review, do you need to continue that operation? Can you do something else? Can you have a team deal with that is isolated and stay on their own? But the mere fact that people cannot remain 2 meters apart does not mean that operation should not be carried out. And one of the interesting questions I was asked yesterday that stumped me is a client who is working on a building that I think is 19 stories high, and the lift, which is causing quite a few problems, as you can imagine, most site lifts. What's being done in that project is that the lift operator has been moved to the top floor with some form of remote control and CCTV, trying to get another 1 or 2 people in the lift. But I stress again, the mere fact that people cannot remain 2 meters apart does not mean that that particular operation does not have to be carried out. There's a lot of detail in the SOP. It governs how people arrive at work. If they share a car, it even suggests keeping the windows open. There's recommendations on some sites for toilet attendants, people to regulate how many people can use the washing and the toilet facilities at any one time. There's a lot there which is basically being followed, but one of the key points of the SOP and SOP 4 are risk assessments. Every operation is to be risk assessed, and SOP 4 went a bit further in saying the risk assessments should be shared with all staff, so everybody knows what they are doing. One other point in SOP 3 and SOP 4, it does not say that face masks are compulsory. It makes a point that regular PPE should be used. If staff wish to use face masks, then it's fine, but it's not a compulsory requirement of SOP 4 or even government advice. Now, at the moment, many projects that we have seen, notices are out there seeking an extension of time, partly because of site shutdowns due to COVID, and partly due to the now restrictive working practices. The issue that has been come up against time and time again is under a JCT contract, a delay for force majeure stroke COVID-19 only gives rise to an extension of time. It only relieves the contractor of the right to pay damages for delays. It doesn't actually generate any money. I stress, as always, the contract words are absolutely crucial. Under an NEC, it's time and money. Money is payable as a result of a delay, different working practices, or to use the jargon, a compensation event arising out of COVID-19. What is happening is that as a result, certain people are looking for reasons why or other relevant events under a JCT contract which may give rise to money. And the things that we have seen is people who are saying that an instruction has been issued, or there's an impediment, another relevant event under a JCT contract. We are preventing from progressing with the works because of this new working regime which the principal contractor has imposed on us. Please bear in mind my previous point about notices. If a notice has not been given, listing these factors, they are not in play. They are not even arguable. So people looking at other terms, relevant events, other breaches of contract, other terms of the contract, which may or may not give rise to money. I'll say again, of the notices we have seen, we have not seen one extension of time being granted. Practically speaking, I'll assume that notice has been given and people are waiting for an extension of time. The key point at that stage is record keeping. Okay? It's absolutely vital that you can show the delays that we incurred as a result of COVID-19 were the force majeure events making, not yours, the extent of the delay. With a site shutdown, that is easier. But restrictive working, that's far more difficult. You have to show that the delay of 3 days in, let's say, March 2020 caused a delay to the completion date, which may be the end of the year, if not even later. So programming, evidence, and key are key documents. We've been suggesting to clients that certainly a daily / weekly record should be prepared, explaining exactly what's happening on site, who is working, and where they are working. That daily / weekly record may or may not then be shared with the employer or the contractor. And it's vital, our experience is that sometimes you find records, daily diaries mention the weather, but they ignore things like the crane collapse today. So it's crucial that those details are looked at so that they contain the details of who is working, where they were working, and why they could not work elsewhere. If costs are to be claimed, it's absolutely vital that they're kept separate from the general costs, the other costs of the project. So if there are charges due to a delayed delivery or labor, non-productive overtime, they need to be kept separate because one of the key points is cause and effect. If there are to be some cost implications, it's very important that these can be shown to be distinctive and separate from the other general costs of the project. Again, from our experience, a timesheet with 7 hours per day for numerous people for 5, 6, 7 days a week rarely explains what they were doing or not doing. So those costs and the records really must be kept separate. I do not promote this in any way, although I was involved in it, but it can prove to be a useful starting point if people are starting to look at what are they doing, because the CLC contractual best practice guidance sets out a lot of these factors. But the idea behind it is to give people some tools as to what they can do going forward. The first thing it gives is a pro forma notice for an extension of time under a JCT contract and under an NEC. I would like to think they've already been given. But what the best practice guidance does as well is give some pro forma without prejudice subject to contract correspondence. It encourages people to try to negotiate and have meetings freely under the banner of without prejudice. So the theory is what they say can't be used against them in the future, and subject to contract, there must be a binding contract in writing, setting out any agreement, and until that is done, the parties are not bound. And the guidance also contains an agenda for a meeting as to the ideas and the items that should be discussed, or suggest that they should be discussed. One of the things I can say is that there is no consensus, unsurprisingly, amongst all the parties that make up the CLC as to who should pay. The guidance says there should be a frank discussion of the financial situation and tries to remind people that if a contractor in trouble can actually cost you more if you insist on your contractual rights. And the whole adjudication, etc. process can be very lengthy and sometimes costly. What I've dealt with there are current projects that are ongoing and suggestions as to how best to protect your position. I'll hand over to David to explain what's the best way to approach new work, and there's still lessons to be learned for current work from it. David.
Thank you, John. Thank you. Well, good afternoon, everyone. I think I'm just going to reinforce one more point that John made. I've been in construction on a night for 20 years. It probably was John that taught me there's only one thing that matters. That's what the contract says. I imagine in the last 8 weeks there have been more contracts dusted off and retrieved from porter cabins than the UK industry's ever seen before to see where the risk sits. And there's a reason that's very important. My second bullet point, English law more or less says to the parties, you're big enough, old enough to divvy up the risks as you see fit. And once you sign the bottom line, you've understood what you signed. Okay, so John has already mentioned, certainly on the JCT, it says it's a force majeure event, most likely, and no money. Now, of course, that came as a surprise to an awful lot of contractors, but the fact is COVID-19 was a neutral event. It was neither one party's fault nor the other. All I would say to contractors listening to this is it's probably fair to say that on lump sum contracts, generally in English law, places probably more risk at your doorstep than it does at the client's doorstep. So things around delays and shortage of materials, just the difficulty of doing the job, unless your contract says that sits client side, it's probably fair to say an awful lot sits your side. I've had numerous contractor clients ask me as well over the last few weeks, isn't there a simple way to fix this, Dave, in terms of some wording I can put into new contracts? There's two reasons why there isn't. I could certainly draft something that says absolutely anything connected with COVID-19 directly or indirectly is someone's lookout. That's a very blunt instrument and a very blunt way of doing it that is unlikely to suit that particular job. The second reason, of course, is every project throws up its own particular issues. As John mentioned, I've got a project that fit out of a 50-story building in central London. That throws up all sorts of issues in terms of getting labour and materials to the 40th floor, wherever it might be. It's the same job that also probably featured in the press with 1,500, 2,000 workers queuing at the turnstiles. That throws up all sorts of issues that my brownfield site out of town where I'm doing the groundwork simply doesn't. Okay, but the one thing is important is you have to look at this going forwards like a lawyer would. My wife is convinced I was born with my glass half empty in terms of seeing what could go absolutely pear-shaped. And of course, as a contractor, as a client, you've got to really look at it that way and say, well, what is there on this particular project that could crop up? And once I've worked out what could crop up, can I turn to a bit of the contract that says that's either my lookout or someone else's lookout, or it's a shared lookout? So it's all about making it specific to that particular project. A blunt tool that simply says it all sits one side or the other side simply won't work. Now, contractors certainly have always been adept at qualifying tenders. There'll be usually something at the back of the pricing document, the back of the ERs, somewhere that says, in doing this job and pricing this client, I've assumed this, I've excluded that, this is not my lookout. Now, we've got 50 or so construction lawyers in our place, and if you look at the top risk of where things go wrong in a project, it'll be documents saying different things. I've lost count of the number of times I've sat down and read the first bit of the building contract, the JCT, the NEC, then someone sends me the prelims, I look at that, and then someone sends me, oh, here's the qualifications, Dave, have a look at that, and they all say completely different things. Okay, so the key thing is, are we clear what the assumptions are in the job? What is not included? What is included? And how are they all merged together to make sure that if you are dusting the contract off in another 8 weeks' time, if things get worse, it's absolutely clear whose side of the fence the risk sits. So what are some of the assumptions we're seeing on jobs now? I think of all the uncertainty around this, the one thing the industry's done really well to grapple with is that certainly contractors now know the effect of social distancing. It might be another 25 to 30% on the program, but that's the one thing actually I think that the industry has got to grips with. Contractors have the guidance, contractors have their own operating procedures, which generally follow it, may even be more onerous and a safer side, on the over cautious side of things, but either way, that's a known quantity. So the issue, of course, is benchmarking that. When I've given a price and a program, I'm benchmarking it against a point in time, version 4 of the rules, my own operating procedures. And the reason that's important, of course, is what John touched on, is that if I am late now 6, 8, 10, 50 weeks down the line, I can show what my baseline starting position was. This was my assumption. Okay. Ironically, there's a lot of building in central London now that is becoming easier. Okay, so if you are doing fit out, there are no tenants in the existing building, for example. So that allows noisy works as almost unlimited. So I'm seeing contractors now that are programming basis, they're programming projects on the best case scenario. You know, on the basis that the tenants don't come back to the building, we'll have a 15-hour crack at it during the day, and there'll be no limit on noisy works. However, bear in mind, if tenants then start to come back and the lifts start to get used and the access isn't as easy, where do we benchmark that as being whose risk it is if it comes to light? Availability of materials is one of the ones, depending who you speak to, there's certain shortages of things. That's probably one of the uncertainties in terms of programming a job going forwards. We can sort the social distancing bit, that's a sort of known quantity. Materials are an issue. I'll touch on that in a minute. All I would say is that some money flowing down from the top of the tree to the bottom tends to get your order as a main contractor to the top of the suppliers list. And if there's a way to do that, that will get a bit more of the security around materials. Finally, the reason again why this is important is because we're trying to baseline what our pricing program is based on to be able to show if things either get better or get worse, what happens. Right, so an interesting point is actually when you're actually starting. What we found about 6 to 8 weeks ago, as soon as the sort of lockdown kicked in, what we found was an awful lot of jobs just went on hold. Okay, there was an immediate knee-jerk reaction, and what were handshake deals about to sign stopped. As we're getting to the end of the period and the lockdown is easing slightly, what I'm seeing is that clients are, well, they're more committed to the job. They know it wants to go ahead. The issue is when, okay? Because if there's still an amount of uncertainty, clients don't want to pay for that uncertainty, of course. So if a contractor's turning around and saying, well, it could be 20 weeks, could be 30 weeks, I might be able to get plastered, but I might not be able to. Clients are committed to the job, but don't want that uncertainty. On the flip side, of course, contractors, and my second bullet point, they want that certainty. I want to know it's in the order book. I want to know it for cash flow purposes. I've got staff on furlough, am I bringing back or not? And I want to secure labour and materials at current prices. So there's a tension there between when we actually start. And remember, in JCT terms, it's very easy to glance over what the start date is. All it is one little entry in the contract particulars that says date of possession is X. And it's that date of possession that starts the clock ticking on your program as a contractor. A normal JCT, most would be familiar with, is it allows the client to defer that for normally up to 6 weeks. What I'm seeing is actually that deferral position is being extended. So the client has the right to defer it for much longer. A couple of reasons. A, just their own certainty around it. Do we want to do it? Do we not? See how things are pan out. The other reason, of course, is some clients may not be able to give possession. So I mentioned my fit out in central London. If the shell and core work has been delayed, the tenant can't give me a date of possession because it's dependent on shell and core PC. I've also seen certain contractors trying to negotiate long stop dates. So if possession's not been given by this date, okay, we want to do a deal, we want to sign, but if I've not had possession by this date, that affects my price because contractors might be able to see some price increases looming and they want a cut-off date there. So what we're seeing sometimes is almost a checklist for starting because pre-COVID-19, both parties were A, willing to start and B, able to start. It's slightly changed now in that contractors are saying, well, I'm only going to start A, when I can do this, that and the other, and B, when it's efficient for me to do so. A contractor who's taken the risk of the inefficiency in working because maybe the client's not going to pay those extended prelims. As a contractor, I want to start only when I can get the most productivity out of that site. So as a contractor, I'm looking to defer that start date to when I know I can get much closer to the productivity I want versus potentially a hit on productivity at the moment. Now, the point is, again, they all need to be covered off because merely relying on a date of possession to contract is not going to cover these sort of nuances, okay? That's covered off when we start. What about when we finish? I think at the early days of COVID-19, before lockdown came in, what we found was, because almost everything was unknown, we had clients and contractors basically agreeing what is, and what John described as the basic JCT position, which is we're all agreed that this is potentially a force majeure and it will give time but no money. Now, that was a very simplistic view of it, but of course at that time no one knew anything else or no other way to do it. Okay, as I said before, since lockdown, the one known entity here, the known quantity, is that we know the social distancing rules has a huge impact on program. And again, depending on the project, I've seen figures of 25 to 40%. It depends exactly where we're working. My office fit out has got a very different impact on program than my groundworks on an industrial estate out of London. Okay. And the other thing, of course, is bear in mind the one unknown there is we don't know whether it's going to get better or get worse. So what happens in terms of benchmarking? I can benchmark what I've allowed for. Then what happens if it changes? If it gets improved and social distancing gets relaxed, I've had some clients saying, well, you're going to come to the table and share some of the savings. And what happens then equally if it worsens, if we get a second outbreak, what happens? But the point is, either way, you've got to know where you started from. Okay, so we've got certain jobs where do we price the worst case scenario and then save? Or do we price the best case scenario and have a discussion later on about the costs and the time? Interesting point that came out last week about the relaxation of working hours by local planning authorities. So you can now, as a contractor, apply to a local planning authority to extend hours until 9 o'clock at night, I think 6 days a week. On a long project, that is a lot of time a contractor can recover. Okay. All I would say, a word of warning to contractors out there, there are two aspects to this. Generally, building contracts will say you must work in accordance with statutory requirements, and that would capture your planning. So if planning says 9 till 4, that's what you've got to do. Secondly, there's often something in the prelims around working hours, which is a contractual thing. If the prelims say you will work these hours and no later, that's a contractual thing. So even though you could have the local authority saying you can crack on till 9 o'clock, you might find there's something buried somewhere else in the contract that restricts those hours. The way to deal with that, of course, now most clients, I imagine employer side, are going to say, well, do you know what? If it doesn't upset too many people, why would a client object to working longer hours? Now, the two issues there potentially is work for landlords, for example, is can they lengthen those hours as tenants start to come back into the building? May not be able to. And what about the nature of where the project is? Residential areas, that's some guidance has been given, I think, to the government along the lines of, well, if it has a significant impact on a residential area, you may not be able to get that. But the point is what allowance is made in the contract. At the moment time now that I'm programming the job, have I assumed that I will get those working hours or not? And what happens if I do or I do not? Okay. My next to last bullet point then, what can we do about the risks in the supply chain? In reality, what's going to happen if there are shortages on certain materials, then you may well find there are substitutions. Typical building contract will not give that entire discretion to the contractor. So think about more flexibility for the substitution materials. Think about whether we can achieve PC without certain risky items being there. So take a high spec office fit out. If we've got a very swanky reception desk coming from Italy, that building could probably still function as an office minus or with a temporary reception desk. You've got to carve that out of the definition of PC, because otherwise, left as it is, it will say PC is when you've done all the work. It'd be much better written is PC has done all the work except these bits, and in respect to these bits, we'll either put a temporary fix in or we'll do it post PC. Okay, again, all got to be clear in the contract. Just finally, a couple of things. I mentioned mitigating the risk of materials. There is no better way than some money flowing down the supply chain. So we're seeing some contractors asking for deposit payments to pass on to secure stock and prices down the line. You will get all the same issues around clients wanting or having to pay for something that is not on their site. Risk of insolvency, risk of it going missing, etc., etc., etc. All I would say as a contractor, we're seeing also materials being stockpiled. If the site allows it, materials being stockpiled on site ahead of when they're needed. So remember, typical building contracts say, I'll pay you and I'll certify those materials as long as they're not brought onto site too early. I'm not going to certify the roofing tiles when you're not out the ground. well, actually, do you know what? I might be buying those roofing tiles now, bringing them to site, and I want paying for them. You've got to change the contract to deal with that. Next bullet point, just in terms of the second wave, when people read building contracts, clause 8 in JCT deals with it all going really, really wrong, so the termination bit. I would suggest that very many people don't read past the money clause, which is 4, okay? But there are bits in there that says if the job is suspended for more than a period of time, either party can walk. So think about whether that is relevant. If we get a second wave, how long does the job have to be suspended for before either party can walk? Best endeavours, John has touched on, it's very, very difficult to give contractors any comfort or clients any comfort as to what is required. All I would say there is be practical about it. If we've identified where the risk is, in meeting my best endeavours obligation, what do I need to do, i.e. and is in the price? And more importantly, what do I not have to do that isn't in the price? Okay, client direct work, we've got a couple of issues now that have cropped up on projects where typical building contracts will allow clients to bring other trades onto site. So a tenant coming in to fit out a warehouse before shell and core PC. Think about the practicalities of it. Do I still want to let them on, or do I want the maximum number of my people on site rather than effectively taking some of my people off and bringing client direct on? Finally, then just clients that work, have repeat business between contracting clients, just check what you've signed previously. There's all sorts of things in there that you might have accepted before that maybe are no longer acceptable. Things like changes in legislation that were foreseeable don't give you any time or money. Almost anything related to coronavirus now, I would suggest, is foreseeable. Who would have foreseen schools would close, right? Having had the schools now closed, I would suggest almost anything to do with coronavirus now is almost foreseeable, okay? And a final sort of problem for contractors, I suppose, is you've got all the same issues down the line, of course, okay? Whatever nuances there are up the line, got the same issue down the line to try and deal with. So just to wrap up, I think it's probably fair to say that very few contracts, whether they are standard ones, bespoke ones, or even amended, are going to cover the sort of nuances they need to cover going forwards. Okay, so it really does pay to think about, with your glass half empty, think about what could go wrong and just try and find that clause that covers what would happen if it did. Jamie, I think I've probably overshot time a tad.
No, that's absolutely fine, Dave. That's no problem at all. There's a number of questions that have come in. Happily, they seem to fit in 3 or 4 groups. So we should be able to sort of cover all the things that have been discussed. John and Dave, you've both talked about force majeure and you've both been discussing social distancing. Had a couple of questions asking about social distancing. I'm wondering whether, instead of being a force majeure event, people might be able to use change in law clauses, possibly as an alternative to force majeure because of the requirement to socially distant.
Shall I go first, Dave? First of all, for construction sites, a lot of the changes that people feel have been imposed have not been imposed by law, they're guidance. For example, the coronavirus regulations, which invoked social distancing, does not apply to places of work. So there's a lot of guidance out there that necessarily is not a change in the law. I believe you can argue it has been a change in the law, because the Health and Safety Executive, Public Health England, have made it very clear that if certain guidance is not being complied with, people will be prosecuted. That strikes me as something that has the force of law. The other issue under a JCT contract, if there's a change in law or it reverts to the UK statutory power being invoked, only gives you time. It doesn't give you money. So it'll get you some way, even if you can get under that particular clause, but it still won't produce any money at the end of the day.
Well, that's interesting. It goes back to sort of what Dave's saying about always read the contract, because sort of clause 13.7 of the FIDIC contract talks about change of law, and that will actually give you cost in certain defined circumstances. But John, just sticking with you for a moment, you talked about the guidance, and you talked about the guidance referring to without prejudice and save us to contract correspondence. Can that correspondence, if it's without prejudice correspondence produced as part of the guidance, then be used in a subsequent adjudication process?
The whole idea that it is not. If it's marked clearly without prejudice, and the guidance says just marking a letter up saying it's without prejudice isn't necessarily enough. It needs to be a genuine attempt to settle a dispute or part of a dispute. So merely barracking someone in writing and head it without prejudice isn't without prejudice. But if it's an attempt or part of a negotiation and it's marked without prejudice, that should not appear in front of an adjudicator at all. And indeed, there's law to suggest they should ignore it.
Okay, thanks. And dealing with documents and notices, or maybe it's not a notice, would an email simply stating that COVID-19 is going to impact the project serve as a notice, do you think? Dave?
There is certainly, again, it's all a matter, both John and I have reinforced, it's exactly what the contract says. So the first thing to do is to pick up the contract and say, well, can I serve emails? And secondly, what does that email need to say? The way to draft these notices, there's no rocket science to these notices, is you pick up the relevant clause in the contract and you just follow through, almost word for word, what it says you need to do. Now, bearing in mind that unless the contract says they are not valid by email, then there's no problem, generally speaking, by serving them by email. What I would say, it's got to meet the requirements of that clause. So to be a valid notice, it's got to say, and the way around it is, again, not rocket science. You find the clause and you just do exactly what it says you to do. And I suppose the best way to do it as well is also to put the thing to doubt, is to say, this email is our notice under clause blah. And then just follow it through. So, but you're right, there's all sorts of law about whether an email meets a notice. There's all sorts of law about whether a meeting notice is sufficient. And there's plenty of law that says actually that's not. But again, it's a matter of contract. You find the clause that says how you serve the notice and who you serve it on. You find that bit and just follow it. And then go to the bit that says in the notice, it must say this, this, and this. There is no rocket science to that. So there's no reason an email cannot be a valid notice, depending, A, you've checked the contract and you've followed exactly what that clause is asking you to do.
Okay, thanks. Dave, I've got a slightly more specific question, because you were talking about extended working hours and, noting that quite often the prelims are going to set out what the working hours are, say 8 till 5:30. If the planner then approves later hours, does the contractor still need an instruction from the client or to work to those later hours?
I don't think so, because if the work, are you saying the working hours say exactly when I'm permitted to work?
Yeah.
Would I think if that is permissive, i.e. you may work these or you must work these hours, yes, we would need a relaxation of that by the client to allow us to work later. Because you've got the two tensions, remember, I've got the statutory bit, I've always got to comply with stat requirements, but what we're saying is the planners are sort of relaxing it a little, but I've got that provision on one shoulder, dealing with the statutory bit, and I've got what my contract says, which is a private thing with my client on the other. If that says precisely you may only work these hours, then yes, you would need whether it's an instruction or whether it's just a consent to allow you to work longer hours. So you would.
Okay, cool. John, going back right to the beginning of the webinar, and you were talking about the fact that as far as you're aware, there aren't any projects where extensions of time have been granted yet for as a result of the coronavirus. So one or two questions sort of concerned about the reality of this is it's actually going to lead to time at large on projects. And I was wondering if there's any advice or best practice that that employers and contractors should be considering in this position if they're unable to agree extensions of time at the moment, partly, I suppose, because of the uncertainties that are being caused by the COVID-19 virus itself. Is time at large something that we should be being worried about at the moment?
I personally don't think so, and I'm aware that people have said on other jobs that if the whole extension of time mechanism is unworkable, time becomes at large. I think that's quite a quantum leap, to be fair, because the contract covers this.
Yeah.
Contract has a force majeure clause. You can then look at it, and you may disagree with the contract administrator, and that's what the adjudicator's for. So I think I can't quite see how time becomes at large. This is something which the contract deals with. It's not been applied correctly, but there is someone who can be brought in and they can deal with it.
Okay, brilliant. I should say that I've suddenly had in the last 30 seconds a flood of quite specific questions. What we will do is we will answer the questioners directly because we're close to running out of time now. But just one quick question, and again, it catches on something you said towards the end of your talk, Dave. Do you think at the moment there's an appetite for parties to reach a sort of sensible agreements amongst themselves, maybe in relation to what's happened over the last 8 to 12 weeks, or maybe with a view to considering and redistributing even risk in respect of what might happen in the future? Or is it just one of those things that it's sort of watch this space and it's sort of too early to actually sort of get any sort of general trends about what might be happening?
Yeah, so what we have seen is it does vary. I think what tended to happen, Jeremy, at the beginning of the sort of lockdown process, I think you found that employers and client side were generally amenable to the difficulties contractors were facing. But I think as the process developed, I think clients have, which is consistent with what John said, has been less sympathy maybe for contractors stopping work completely and saying, well, hang on a second, you can still crack on. Now, of course, the reason for cracking on is that as a contractor, sometimes it's just cheaper for us to suspend rather than to work at half productivity. I've seen a few projects where we have had a very sensible dialogue for what's happened so far. So we've got, sometimes there are sort of informal suspension agreements or more formal suspension agreements that recognises that the work has stopped and the work will restart on a certain time. Now, again, that's very dependent on the relationship between contractor and client. So there's plenty of contractors out there with repeat work with client that's been a bit more amenable, maybe. Going forwards, I think the only way is, yes, there's a very sort of open approach to what the issues are. So in terms of how that's documented, then yeah, it's a question of really having that dialogue, because if the dialogue isn't had, and my first bullet point is, I think if you sign the contract as it is, an awful lot of problems are at the contractor's side of the fence and not the client's.
Okay, that's brilliant. Thank you. And that's perhaps something that we can all discuss again in 3 or 4 weeks' time, because it's our intention to run a further update of this particular webinar, probably on the 25th of June. We can actually discuss what's been happening over the last 3 or 4 weeks. So thank you very much, John. Thank you very much, Dave. And thank you very much all for listening and paying attention to the webinar. And thank you all for the questions. And I'd just like to finish by reminding you that next week we're absolutely delighted to be welcoming Mrs. Justice O'Farrell, the judge in charge of the TCC, who will be joining Simon Tolson and Stacey Sinclair to discuss virtual hearings and virtual mediations, and wondering whether they are the future of dispute resolution. So I very much hope that you can join us next week. Until then, goodbye, and thank you very much for being part of our webinar.